Ms. Nye.
Good morning. May it please the court, counsel. Melinda Nye with the Appellate Defender's Office, representing Darreon Draine in his appeal. Because Senate File 589's amendments to 814.6 are not retroactive, they don't affect Mr. Draine's appeal, and because he's established that he was entitled to a competency hearing in the district court, his conviction should be reversed and remanded for further proceedings. Senate File 589's amendment to 814.6, under any analysis that this court, that the legislature's provided regarding prospective versus retroactive application of statutes, under any analysis that we do in the state, indicates that it should be applied prospectively only. We've got authority under James v. State and that line of cases that the laws and regulations governing appeals are the ones in effect at the time of the judgment. Additionally, section...
What do you make of the Hammond case?
You know, Hammond, that was, I think, sorry, Justice Waterman, there you are, I was thinking you had mentioned this, that was increasing a remedy or right, it was expanding rights to defendants, and that goes along with the line of cases that if the law is restricting rights or limiting remedies, this court will presume that it's prospectively applied only. If it's expanding rights and opening up remedies, that it will apply those retroactively or deem those procedural only. So that's the other line of cases. Section 4.5 is the legislature's own statement that statutes are presumed prospective unless explicitly made retroactive, and of course the savings clause. So sort of any of these avenues that are recognized say that it's prospective. I guess I'm curious whether you want to talk about the merits or good cause.
I want to talk about the merits.
Yeah.
Do I read the record right that the IQ of your client was 60?
Yes, that's what it was. The point, like his overall IQ was in the 0.4 percentile, and his verbal IQ was 0.1 percentile.
So there seems to be, well, I've looked at some cases on that particular question.
Mm-hmm.
And I would say what I found is when IQ is between 50 and 70, sometimes the courts have a competency hearing and sometimes they don't, depending on all the facts and circumstances. I just characterize. They tend to be kind of fact specific. Mm-hmm. What do you have beside the 60 IQ
what we've
that
got
would really power this thing toward a competency?
Right. What we've got are the medical records. So we've got the medical records that establish the low IQ, but also establish this long history of behavioral problems, of lashing out against people that are trying to help him, threats against his family and counselors, as well as the lawyer's statements, who's trying to interact with him, who says, I get the feeling he doesn't understand what I'm saying to him.
Yeah, the state makes a lot of lawyer statements, and some of them support your position, but the state points out, well, but sometimes the lawyer tends to minimize it too. Well, if I talk to him a little bit, it gets straight.
Yeah, he says he got through the one. He gives the example of the one interaction, and that he said, of course, when he first went in, he didn't know who he was. He mistook him for a different attorney or someone else, and then sort of finally got it figured out. He said we got through what we needed to get through, but then immediately afterwards, he's threatening him, and why are you talking to me? Why are you looking at me? The test is whether he, can competently assist his trial counsel, and whether he understands the proceedings against him. And so if whether it's related to his low IQ, I think that's what the medical records indicate, that the low IQ may be tied into the behavioral problems. And
I think you honed into a lot of issues that we see every day in court. Lower IQ, behavioral outbursts. I think you also said threats against his family. Mm-hmm. Tell me something I don't know. I mean, that's pretty common, sadly. But I think you're hitting some hot spots when you talk about the attorney's own statements when he's trying to interact with his client and be an effective attorney. But don't you think the district court did a pretty good job, a pretty thorough job? Every time there seemed to be a threat that there's something maybe not right, wasn't there an adjournment or an opportunity for the lawyer to visit his client, or perhaps the judge engaged in, I think, a colloquy of about 40 different questions, I think the brief said?
So the colloquy The plea.
Anytime that the court made, I think the Court of Appeals also commented on all of the extra efforts that were made by district court as well as the defense counsel to try and get it to a level where the court was satisfied. Do you think the court should have done even more?
So first of all, the sort of the competency motion was made before he ever entered his plea. So the question was, at that point, did that judge have reasonable, would a reasonable judge have believed he needed a competency hearing? So that was before the care was taken. So as to the entry of the plea, it crossed all the dots or crossed all the T's and dotted all the I's and met the formal requirements under the rule. But I think I cited we've got this low verbal IQ, and there's one sentence that's 93 words long, and that stuff's hard to understand for anybody.
Don't the medical records have a note? I'm looking at page 43. The doctors think he is functioning higher than what his IQ shows. Mm-hmm. Isn't that right? That
is, yeah. So that fits in with Einfeld, that there could be the question of malingering, or that they don't have a good assessment. But that's
maybe not malingering, but just maybe more of the oppositional, defiant behavior that is just generally antisocial conduct, right?
It could be, but at this point, there's enough to warrant investigating further. This isn't saying he's absolutely incompetent to stand trial.
But he was investigated. He was seen prior to the guilty plea, but by mental health professionals, and none of them really diagnosed him as having a mental illness. They just said he was an oppositional, defiant, antisocial kind of individual, right? Mm-hmm.
And you're talking about the 2013 record, all the records that are in there. Yeah, they can't quite figure it out. They can't get him medicated. They can't. But I think there's enough. And then, given that he needs to understand what's happening, he needs to work with his attorney. The attorney's struggling with that. There's enough there to.
But isn't the trial judge better positioned to determine, seeing him firsthand, looking at him, listening, handling the colloquy, on that determination, he's capable of understanding the charges and working with his defense counsel. It seems like the trial judge is. We should give a lot of weight to that than ourselves reviewing all this on a cold transcript.
First, he wasn't in court that much. This isn't, really, and even in Einfeld, it was reversed, even though the trial court there got to see her at trial and acting erratically. We didn't have the benefit of lots of days in court. He'd had a couple of hearings. The plea colloquy is taken by a different judge. Is that right? Am I getting confused? There's two different judges at issue here. But the competency hearing, the request for the competency hearing is relatively early on, and before the judge has had much of a chance. And at that point, that's why the judge should rely on the lawyer. And lawyers, I don't see a lot of competency motions, even if this is normal erratic behavior and stuff we see in the courts from defendants maybe frequently. The fact that the lawyer feels strongly enough to make a motion and bring this evidence to the court and raise his concerns, that should be something the court should be relying on.
But that probable cause determination is left for the judge, correct? The district judge.
Yes.
And I think that's what perhaps Justice Mansfield was referring to. Mm-hmm. So it seems to me that the court did do what they thought was their job. You just don't agree with the sufficiency of the evidence in him making a probable cause determination?
Yes, it's a legal decision, so it's not a discretionary decision. Once there's a sufficient level of evidence that a competency hearing is warranted, it's no longer a discretionary question. It's a legal error.
Could you speak to the definition of good cause?
Yeah, I think it's really important that the legislature use good cause. Good cause is broad. It's all over the place. You find hundreds of hits on Westlaw. As a legal standard goes, it's a pretty low legal standard. The legislature didn't define it, didn't give examples of what might constitute, leaving it to this court to decide what good cause means and to interpret it in a way that ensures due process and equal protection, and in a way that is efficient. It's up to you to decide how to interpret it. If the legislature meant it to be extraordinary, or there's words for that. They could have said only, a defendant may only appeal after guilty plea in extraordinary circumstances or in unusual and compelling circumstances. But the legislature didn't do that. It said good cause, and we know that good cause is a fairly low standard as far as the quality of the claim to show that it's non-frivolous. Substantively, I think that to avoid equal protection problems, if a person who goes to trial, if I may finish, person who goes to trial has the same substance of a claim and has an automatic right to appeal and review of that issue, that this court should interpret good cause to ensure that someone who pleads guilty is not being discriminated against unfairly and has the same right to appeal. Thank you.
Ms. Nye, thank you as well. Mr. Buller.
May it please the court. I want to talk first about one of the practical aspects of Senate File 589 that I think maybe there's been a little bit of confusion about today, or maybe we've moved past a little too quickly. I think there's been some suggestion that there are defendants who had substantive claims before July 1st that they don't have after July 1st, and that is not true. Every claim that could have been raised before July 1st can still be raised after July 1. The tribunal that's going to hear that claim might change. Ineffective assistance won't be heard on direct appeal. It's going to be heard in a post-conviction case instead. But every single claim that could have been heard under the previous statutory regime can still be heard by an Iowa court, maybe not the same court, but by an Iowa court, and those substantive rights can still be vindicated.
You heard my colloquy with Mr. Parrish on delay, and among other things, I asked the question, well, can you simultaneously file an 822 and a direct appeal, and or does the direct appeal get stayed? Or you understand the relationship. The general problem that he was raising is, does this mean that if oh, okay, that's not
ominous.
Me. Okay. Oh boy. His concern was that, well, ineffective assistance of counsel claims could end up leading to a 2-year delay. I think you understand the issue. Why don't you address it, please?
I do. I don't think the concern is realistic. More often than not, if there is what I would call a clear-cut ineffective assistance claim, that can be litigated in a post-conviction action faster than this court could decide the direct appeal, weigh whether or not there's even sufficient record to decide it.
But can you file them both at the same time? Can you do a direct appeal on the other issues and then do a PCR on ineffective assistance?
Nothing in the statutory language would prohibit that. I think there are some cases where for judicial economy reasons it doesn't make a lot of sense, right? There could be claims where you're sort of trying to double litigate things. You could walk yourself into a res judicata problem if you were trying to raise something and then trying to litigate it a second time.
But, I don't follow your efficiency argument, Mr. Buller, because you're saying the PCR would move faster than a direct appeal, but generally speaking, the direct appeal has non-ineffective assistance issues as well. And those would still need to be resolved by us. So you'd have to wait till that's done, then go back down and do a PCR. So you still have the delay that's been discussed this morning, wouldn't you?
Well, I think there are two issues with that. First, not every case has preserved errors that this court would reach on direct appeal. Sometimes the only live claim is going to be an ineffective assistance claim. If I'm that defendant, I go straight to post-conviction relief. I file the 822 application as soon as sentencing happens.
I mean, and then what do you do? What happens with federal habeas? Have you exhausted?
That question has not been resolved.
You're at risk, aren't you, as a defense lawyer, if you don't do that?
That question has not been resolved. Obviously, I'm not an habeas expert, but the general answer is you have to have your full litigation of the claim to final exhaustion in state court. If we've shifted ineffective assistance to PCR cases, the federal courts might end up holding that that's how you have to fully litigate that ineffective assistance claim to preserve a substantive federal constitutional claim. I don't know what the federal courts are going to say on that issue, but I would suggest to this court that that isn't dispositive of what we're talking about today. The reality is that if you have one discrete preserved error that you want to raise on direct appeal, you can do that and then bring your ineffective assistance claim in that 822 as soon as you want to. A judge might think that should be stayed in the interest of judicial economy, but there's nothing that prohibits that from happening.
Mr. Buller, would you agree with me that this issue of retroactivity or retrospective or prospective on 814.61 Give it a few months, maybe a couple years, it's going to be moot. I mean, eventually the cases that are in the system right now are the ones we're talking about, right?
Yes, ma'am.
So why not let them go? Let my people go. Why not?
I understand the fairness and the equity principles that underlie your question. I understand that if this were an equity case, maybe we would try to fashion a remedy to help those people out. But of course, this is not an equity
I'm
case.
not just talking equity. I'm talking judicial economy. I mean, that stuff's already in the hopper. People are already working on the case. There's already a case number assigned to. I'm having a hard time being persuaded that people who entered into a plea or are found guilty and heard, like I said, that district court colloquy, it's different today than it was pre-July 1. I can't imagine district court judges are doing business exactly as they used to do before.
Well, I hate to tell you, but I've done a sentencing and a guilty plea and a felony since July 1st, and nothing changed in the colloquies. So I'm not sure judges are doing it differently. But more to your original question about judicial economy, whatever principles prompt the questions of shouldn't we do something
Good cause.
for the folks whose cases are in the hopper, those were arguments that are had at the legislature. This court does not have the ability to fashion policy and to rewrite statutes.
But
We have good cause.
Don't we presume the legislature is aware of the laws, the cases on the books? And in James v. State, we gave direction that unless the legislature clearly indicates otherwise, statutes controlling appeals are those that were in effect at the time the judgment or order was entered. So with that, out there, I don't see any express retroactivity language in the statutes we're talking about.
So 2 reasons I disagree that James controls here. Well, 3, really. First, I think James is wrong for the reasons we lay out in the brief. But even if you don't buy anything I have to say on that, Hannon cannot be resolved with James on its face. If we're looking for a more recent approach that this court has taken to prospective versus retroactive application of statutes, Hannon's the case, and under Hannon, the state wins here too. But even setting all that aside, the legislature is presumed to know the law. If you go onto Westlaw and you start doing searches for how do jurisdiction stripping statutes get interpreted, you end up with all the federal cases, Landgraf, Hallowell.
That federal law, my federal court student left, unfortunately, but that federal law, that dates back to like the Civil War. And we've always followed a different approach, and James exemplifies that. So, why do we say that federal law overrules James?
Well, I'm not sure overrules is the right word. I do think the court probably has authority to determine what the standard would be for interpreting the Iowa Constitution and how the legislature's interplay with this court works in statutes and appellate jurisdiction. But if we're going to talk about the Iowa Constitution, let's talk about the Iowa Constitution. Under the Iowa Constitution, the General Assembly can regulate jurisdiction under such restrictions as may by law be prescribed. That's what the General Assembly has done here. They've prescribed restrictions. And the point of...
And no one disputes that. It's just when do they become effective?
And that's why I think you do need to look at these federal cases, because the point of inquiry is when someone is asking this court to exercise the judicial power. And obviously that's what the appellate defender is doing here. They're asking the court to exercise its judicial power to grant relief to her client. But the legislature has spoken. They have taken away the judicial power for this court to correct an error in law.
Couldn't they have spoken more clearly and simply added a sentence? This applies to cases pending. This applies to guilty pleas entered earlier.
I think the legislature did speak clearly by relying on the effective date of July 1st. We are not regulating the defendant's conduct in this case. We are regulating the conduct of this court, of the exercise of this court's power. So we don't care when the defendant did something in this
Doesn't
case.
that, everything you just said, apply to the situation in James, and our court unanimously went the other way?
I think that's right. The jurisdiction stripping argument really wasn't presented there. The federal principles we're talking about today, as far as I can tell, they weren't raised in the briefing. They certainly are not discussed in the court's decision in that case. And I'll admit, if somebody needs to fall on the sword for that, it can be the state. We could have briefed that issue in James and apparently did not. But the principles of these federal cases are compelling if what we're talking about is a regulation of the exercise of the judicial power. The substantive event, the determining event, is when the court exercises its power. And that's today, which is obviously after July 1st.
Mr. Buller, you said, and lucky for you, I take shorthand, every claim that could have been raised before July 1st can be heard afterwards. And then there was like a little footnote, and you moved on quickly, but you did say the tribunal might change, and then you kept going. Whoa, take a step back. Isn't that kind of substantial that the tribunal changes? You go from criminal to civil. Don't judges look at cases differently? Aren't they prioritized differently by mandate of the Supreme Court? Criminal trials are to take priority. I mean, I don't think that can be dismissed so easily. Can you help me understand how that, even if I would agree with you that's the only thing that's affected, which I do think there might be more to it, but given you that, how come the tribunal changing isn't given more consideration by your argument?
Because every court to consider the question has said that when the only thing that changes is the procedures or the tribunal to hear the case, it is a purely procedural change that is retroactive. Now, the example for something that would move from criminal to civil, that's really only going to be ineffective assistance claims. That's what 814.7 has done, taken them out of the criminal context, put them in the civil context. Of course, that's how we are already deciding 90+% of these ineffective assistance cases. The legislature had previously expressed a preference for that. This court, time and time again, has said that ordinarily ineffective assistance cases require litigation in a post-conviction case. So nothing substantive has changed about how those claims will be litigated. Most of the time it is better that they are litigated in an 822 because all these discovery tools are available. You can put the defense lawyer under oath. You can find out what happened. In a case like Mr. Ogden's from this morning, we can try and determine what actually took place in the district court when that is not readily available.
I have one additional question on what I'll call the Einfeld issue, so we're going to move on to the substance. And that is this. There's a substantial literature out there in the scientific community about the impact of developmental immaturity when there's also mental illness. And there's a MacArthur study in 2003 that goes into it in great depth. And actually the question that's posed in this MacArthur study, I will tell you, is competence. And the study, I'm going to be a little too fat maybe, but the study basically suggests, well, if you're analyzing competence of youth and mental illness, you have to factor in developmental issues and suggests that, in fact, in juvenile settings, the lack of competence is higher than in adult settings. I'm kind of paraphrasing, and I hope you'll indulge me. But the basic question is, well, okay, so this is a juvenile, and do we not consider the fact that the mental illness can have greater impacts on juveniles who also have developmental lack of developmental development? You get my general question. I want to give you an opportunity to respond.
I do. I see I'm quite a ways over my time. If I could go ahead and answer. Is it possible that there is, a nexus between mental illness and developmental delays or problems with some offenders? Yeah, absolutely. I'm not sure that is what's happening here. The district court was in the best place to assess things. What I read from this record, admittedly reading the cold transcript just like the court is this is a difficult guy. He's kind of a jerk, right? He's not treating his lawyer very well. He seems to have threatened his family. He obviously has violent tendencies. Those descriptors could apply to a lot of violent offenders, perhaps the majority of violent offenders in the state of Iowa. It cannot be that every time an offender is violent and difficult with his attorney, he gets a competency evaluation. The questions are necessarily different.
Sure, although 60 is very low IQ, and I did look at some cases, and I will tell you the facts. I mean, they're all fact-based, just as this one's going to be fact-based, I think, largely. But it seems to me the cases kind of strike me as standing for the proposition. If you have 60 IQ, that puts you on notice of looking around. And I think your argument looking around might be, well, okay, we look around, there's not a whole lot there. But the bottom line is developmental delays can be a factor. I think you somewhat concede, but you say on the record here that we don't have it.
I would agree with that. I also think using the 60 number sort of at face value is problematic. Even the providers suggest that may not be an accurate reflection. And of course, even looking outside the confines of what we're talking about here, IQ tests are very problematic. There are language issues. There are a number of studies that find race-based and socioeconomic-based differences in IQ that can't be explained otherwise. 60 on its own doesn't tell us a whole lot. We've got to look a lot beyond that. And the best evidence that we've got here is that 40-question transcript. The judge did a pretty good job of walking things through with the defendant. It's clear the defendant talked to his lawyer. It's a pretty coherent transcript other than the 2 times the defendant gets confused, asks a question to his lawyer, which I think we'd find with a lot of defendants when there's legal language, and then the judge carefully walked through everything. There's no probable cause for a competency hearing on this record. I would ask this court to find that SF 589 does apply, and if not, affirm both the district court and the Court of Appeals.
Mr. Bowler, thank you. Ms. Nye.
Thank you. I do want to address a couple things that I started to address first and then have come up again. The idea that his IQ being 60, but that maybe he's functioning at a higher level. I read that, and this would be why it'd be good to have the evaluation, but the functioning, can he get up and get himself dressed and eat breakfast is sort of functioning is different than a verbal IQ and understanding the legal proceedings against him, being able to work with his attorney in his defense. And then that goes as well to the plea colloquy that, like I said, legally it covered the bases, but I've seen guilty plea proceedings that have been dumbed down a lot more effectively, that are really break it down into small sentences, into very easy to understand words. I think there's still a lot of legalese, a lot of technical language used, which sometimes you can't avoid, but there are some concepts that can absolutely be explained.
Here, let me just quote from the sentencing. He's asked to, and I agree it's the sentencing, but it's within the same general time frame. He's asked to give his version to allocute, and he says, I shouldn't go to prison or nothing because I didn't hit the dude with the radio. I hit him with my closed fist. So I shouldn't go to prison or Eldor or anything like that. I should be on probation here with my mom, my family. So that's all I got. That sounds like someone who understands the proceedings and is capable of assisting his lawyer, doesn't it?
I think it shows he understands he's going to prison now. It doesn't mean he understood what all the rights he was giving up when he pled guilty, or that he understood he was pleading as charged. He didn't get a benefit for pleading except to not go to trial, and his attorney had expressed concerns about putting him in a courtroom and how he would behave in front of a jury. So it definitely shows some sort. He's talking and articulating, but I don't think it necessarily shows that he understood the rights he was giving up when he pled guilty and understood the nuances of a trial and calling witnesses. But when he's being told, tell the judge why you shouldn't go to prison, I think that's a much narrower issue to address. And I don't know, I think the jurisdictional stripping analysis requires a lot of legal gymnastics to get there, and for what policy reason. I'm not sure why the court would want to overrule precedent and ignore our cases, distinguishing between subject matter jurisdiction and authority, and sort of throw those to the side just to adopt what is admittedly a narrow exception under federal law for jurisdictional stripping statutes, when the statute doesn't explicitly strip jurisdiction at all. It regulates defendants' ability to get into an appeal. For those reasons, because Draine did establish that he was entitled to a competency hearing, and because Senate File 589 is not retroactive, we ask that the court vacate his conviction and remand for further proceedings. Thank you.
Ms. Nye, thank you as well. Mr. Bowler, thank you again. The case of State versus Draine is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.